Alright, hello class. Today we're going to continue our lesson on the topic of adverse possession. So I've already mentioned in the classroom when does the time start to run and then the reasons for having adverse possession in the first place. So for today's class we're just going to continue where we stopped. That is under the unregistered land, whereby a squatter or adverse possessor can make a claim of adverse possession, in particular if the land is unregistered under section 15 and also 17 of Limitation Act 1980. So if a squatter can make a claim under section 15, means that he has occupied the particular piece of land for 12 years. And as such, it will trigger the application of section 17, in which the title to the original owner will be extinguished. So this is the effect of adverse possession by a squatter under unregistered land. So apart from relying on the statutory provisions, there are also other criteria that need to be satisfied by the squatter himself. So in the case of J.A. Pye against Graham, the court has established two key elements before an adverse possessor can actually make a claim. So one is factual possession and one is intention to possess. So under factual possession, it is important for a squatter to actually exercise his physical control over the piece of land. So we're talking about physical control. It usually involves an act of enclosure. Means that you set up barriers, you set up gate or fences, or you even plant hedges to prevent other people, including the true owner, from entering into the property and piece of land. So you must establish physical control. So for example, in the cases of Buckingham, CC and Moran, Powell and McFarlane, you can see, especially in the first case, whereby Mr. Moran has changed the lock, changed the door, in a sense that only he himself has the key to the house. So as such, he is excluding the world, including the true owner, from entering into the property. So because of that, court says that he has established that he has factual possession over that piece of property. So in the case of Powell and McFarlane, this is different. So what happens in this case was that you have a 14-year-old boy who grazed cows on the neighboring land. So this was when he was 14 years old. So his grandmother wrote to the neighbors saying that whether he would allow his grandson to actually to exercise physical control over the piece of land, whether or not he can graze cows on the neighbor's land. So she received no reply. So the act continues, but in the period of 1956 until 1957, there was no activity whatsoever. So it means that there is a gap or there is a break in the chain of the adverse possessions claim. So after he completed his secondary school, so he had this intention that he want to physically control the neighbor's land. So as such, he started to erect advertising board, business signs saying that now he wants to have a business over the neighboring's property. And subsequently, the neighbors came and then inspected the piece of land. She found nothing unusual. She obviously seen the sign, but she didn't say anything. So now the issue arises whether she has consented or gave permission to allow the boy, who is now 18-year-old man, adult, to continue occupying the piece of property. But in this case, court held that because he did not manifest the intention when he was 14 years old, because it was during his summer break whereby he wants to graze cow, and also because of this, there is a break in the chain in his claim to get adverse possession. So as such, court said that there was no factual possession in this case. So as such, he cannot claim that he has adversely possessed the lands of the neighbors. So there are few criteria that you need to establish. So apart from factual possession, remember you need to also prove whether you have dispossessed the owner or whether there is a discontinuation from the owner itself. So that's the first thing you need to establish. Secondly, you need to establish these two elements: factual possession, whereby you exercise physical control over the piece of land, and also it must be shown, as per the case of Powell and McFarlane, that there has been continuity, in the sense that your occupation you have occupied a particular piece of land for the period of 12 years. So as such, then you can make a claim that you are a squatter or a valid adverse possessor on a neighboring's land or other people's land, for a matter of fact. So once you have proved you have factual possession of the piece of property, the second element you need to prove is the intention to possess. This is actually very important because even though you have exercised control but you did not manifest the intention, you cannot make a claim of adverse possession. Means that even though you occupied for 39 years, your field will collapse because you will be unable to prove your intention. So how do you prove your intention to possess? So in order for you to show to the world that you have the intention to become the owner of that piece of land or owner of the piece of estate, you must exclude the whole world. So we're talking about the whole world, you're saying that everybody, including the owner. So it means that the owner would not be allowed to enter into the property, wouldn't be able to give any consent or permission, means that he is unable to do anything over his own piece of property for the period of 12 years. So the clear example is the case of Powell and McFarlane. So even though he has erected a business sign, but the thing is, because he did not manifest his intention when he wants to make a claim that he already grazed cows since he was 14 years old, so that's the reason why his claim collapsed, failed. Because what he wants to do is to make a claim since he was 14 years old. But because remember there is a break in the chain, so he was unable to satisfy the 12-year period continuously, and also his intention to possess. Second and third case is Lambert and also Buckingham, CC and Moran. These two cases shows that if you have a factual possession over the piece of land whereby you erected gates and then you change the chain or change the locks, and subsequently you manifest the intention you want to evict the owner or you want to exclude everybody including the owner itself, then you can prove that you are a valid adverse possessor as long as you satisfy the factual possession and also intention to possess. But you need to remember, when it comes to declaration of intention alone is not enough. So it's not suffice just merely to say that I have this intention to occupy this house for the next 12 years. What you need to show proof is that you actually need to occupy that place for 12 years. You must show proof, and from the beginning itself, you'll be able to show to the world, to the court, to the owner that you have the intention to occupy the place. So that's very important because in this case, he did not occupy for a 12-year period, he's merely having a declaration. So the court says that it's not sufficient. And the last case is the case of Betts and Adams. So what happens in this case was that the adverse possessor erected fences. So now you have fences, but you also have animals within the compound. So now the issue arises whether the fences built are to prevent the animals from going out or to prevent other people from coming in. So in this case, it was established that the reason why the fences were erected was because to prevent the animals from going out. So the adverse possessor cannot establish that he has the intention to possess that piece of estate. So as such, his claim also failed. So these are the few examples of cases whereby you need to prove that you have factual possession as well as intention to possess to make sure that you have a successful claim under the law of adverse possession. So now, the last issue arises under the unregistered land is when it concerns a piece of property which has been leased out to tenant. So this one particular tenant renting a particular place. So you have a house and you have an owner, Mr. X, leased out the property to Mr. Y. So let's say for the period of 20 years. But let's say 5 years later, Y went overseas and Y forgot everything about this house. He forgot to pay rent and he abandoned the property totally. So now you have Mr. Z who came into the property and occupied the place for 12 years. So he can establish that he has factual possession, he can establish that he has intention to possess, but now the issue arises whether he can make a claim as a successful adverse possessor. So in this situation, even though Mr. Z has occupied the place without permission or consent from Mr. X and Mr. Y, he cannot make a successful claim as adverse possessor. The reason being is because he merely occupied for 12 years to displace the original tenant. Means that he did not defeat the claim of Mr. X. So Mr. X is still the lawful owner of this house, and Mr. X can evict Z at any time as he chooses, even though he has occupied the property for 12 years. But as for Mr. Y cannot evict Mr. Z at all because he has been displaced by the period of 12 years occupied by Mr. Z. So I hope you guys understand. So far we've already covered the law of adverse possession, whereby an adverse possessor can make a claim as a valid squatter or successful squatter for unregistered land under Limitation Act 1980. So my next video I'll cover how you can make a successful claim as adverse possessor under registered land by 1925, and subsequently what are the law if you want to make a claim under Land Registration Act 2002.